Yes, Lord Anderson.
No, it's a Belmarsh case. It's at tab 15 of the authorities, page 640. And I'll start, if I may, with the headnote on page 641. Held 1, and this is the issue about whether the derogation was necessary to deal with an emergency threatening the life of the nation, whether that condition was met. And then we're concerned with number 2, Lord Bingham, Lord Nichols, Lord Hope, Lord Scott, Lord Roger, Baroness Hale and Lord Carswell. That's 7 out of the 9 agreeing with this. Lord Walker, I think, dissenting. Lord Hoffman not expressing a view, but the suggestion was because he wasn't sure they'd gone far enough. That although the response necessary to protect national security was a matter of political judgment for the executive and Parliament, where convention rights were an issue, national courts were required to afford them effective protection by adopting an intensive review of whether such a right had been impugned, and the courts were not precluded by any doctrine of deference from examining the proportionality of a measure taken to restrict such a right. The right to personal liberty was among the most fundamental rights protected, and the restrictions imposed by Section 23 of the 2001 Act called for close scrutiny. Since 2003, they then go on to talk about Section 23, which applied to non-nationals, but not to United Kingdom nationals, and that did not rationally address the threat to security, was a disproportionate response, and was not strictly required by the exigencies of the situation, and that since there had been no derogation from the prohibition on discrimination in Article 14, since the relevant context was that of security, and since there was a difference of treatment, the measure unjustifiably discriminated against them on grounds of nationality or immigration status. So those issues of proportionality and discrimination went really side by side, and you'll see that the speech of Lord Bingham refers to both of them in order. And turning to that speech at 661 of the bundle, he sets out the basic facts. Of course, I think I forgot my Lord Justice Singh was in this one too, so I be careful what I say. But he sets out the facts in paragraphs 2 and 3. 8 of the appellants were certified and detained just in the months after 9/11. The 9th, a little bit later. 2 of them exercised their right to leave the United Kingdom. 1 was transferred to Broadmoor. And paragraph 3, certain common characteristics. All were foreign nationals. None had been the subject of any criminal charge, nor any trial in prospect, and all challenged the lawfulness of their designation. Then going on to paragraph 7, Her Majesty's Government reacted to the events of 11th September in 2 ways directly relevant to these appeals. First, it introduced, very swiftly enacted, what became Part 4 of the 2001 Act, and then secondly, it derogated, issued a derogation order in relation to the ECHR. And paragraph 8 refers to the well-known principle in Hardy or Singh, whereby a person maybe against whom a deportation order has been made may be detained pending his removal or departure from the United Kingdom, that being permissible only for such time as was reasonably necessary for the process of deportation. So there was no warrant for the long-term or indefinite detention of a non-UK national whom the Home Secretary wished to remove. Then they rehearsed Article 5 of the Convention, and over the page 92b, there's an exception in F. There may be an exception for the lawful arrest or detention of a person against whom action is being taken with a view to deportation. Then there's reference in paragraph 10 to the derogation in time of emergency, when the European Convention allows you to do that. The derogation order is outlined at paragraph 11. At paragraph 12, Lord Bingham comes on to the power under Section 21 to issue a certificate if the Secretary of State reasonably believes that the person's presence in the United Kingdom is a risk to national security and suspects that the person is a terrorist. So you have those 2 tests side by side, the belief test and the suspect test, and slightly different things, but they both had to be satisfied. So you could say a tighter test than the sanctions regulation. Then going on to paragraph 14, you see that section 23 is the provision most directly challenged in these appeals. It provides effectively reversing Hardyal Singh or suspending Hardyal Singh in this category of case. A suspected international terrorist may be detained despite the fact that his removal or departure from the United Kingdom is prevented by a point of law which wholly or partly relates to an international agreement or by a practical consideration. So if you wanted to deport someone but their country of origin wouldn't take them back, or if there was some Article 3 reason to think they might be tortured, for example, if they were deported, then that would be the sort of reason, no doubt, that Parliament had in mind. Then there's a section on public emergency, which I don't think we need trouble with. But going on to page 674, near the bottom of that page, Lord Bingham concludes favourably to the Secretary of State in relation to that issue, what was described as the preeminently political judgment of whether there was a state of emergency threatening the life of the nation. And he concludes that the appellants have shown no ground strong enough to warrant displacing the Secretary of State's decision on this important threshold question. And he then goes on to consider proportionality. And at page 675 at the top, the appellants founded on the principle in de Freitas, and the ingredients of proportionality as they then were set out. You see from Bank Mellat that, of course, those ingredients were refined a little over the years, in particular by the addition of the fourth element about the fair balance. And he makes it clear the approach owes something to the Canadian model. Then I think we can go on a few pages to paragraph 40, where Lord Bingham says the Convention regime for the international protection of human rights requires national authorities, including national courts, to exercise their authority to afford effective protection. And Handyside is cited, and so are others. Then at G, in Smith and Grady, the traditional Wednesbury approach to judicial review was held to afford inadequate protection. It's now recognised that domestic courts must themselves form a judgment whether a convention right has been breached, and that the intensity of review is somewhat greater under a proportionality approach. That was Daly. Even in a terrorist situation, the convention organs have not been willing to relax their residual supervisory role.
Lord Anderson, just to go back for a moment to Smith and Grady.
Yes.
As is implicit in what Lord Bingham says there, it may be worth recalling that in Smith and Grady there was found to be breach of Article 13. In other words, that English domestic administrative law did not afford an effective remedy because Wednesbury Review didn't allow the domestic court to review proportionality.
Yes, I entirely agree, and I'm grateful to your Lordship for pointing it out. That was the gaze in the military cases, it's sometimes called. Then Korematsu is cited on the following page, 682, and then Simon Brown is cited in International Transport. Roth is saying constitutional dangers exist no less in too little judicial activism as in too much. There are limits to the legitimacy of executive or legislative decision-making, just as there are to decision-making by the courts. It follows from this analysis that the appellants are, in my opinion, entitled to invite the courts to review on proportionality grounds the derogation order and the compatibility of the Convention of Section 23, and the courts are not effectively precluded by any doctrine of deference from scrutinising the issues raised. And then between F and G, the function of independent judges charged to interpret and apply the law is universally recognised as a cardinal feature of the modern democratic state, a cornerstone of the rule of law itself. Then over the page 683, paragraph 43, and he's still, of course, on proportionality. The appellant's proportionality challenge to the order and Section 23 is, in my opinion, sound for all these various reasons. And at letter E, the conclusion that the order and Section 23 are in convention terms disproportionate is, in my opinion, irresistible. Then moving on over the page to the highlighted section on 684, assuming as one must that there is a public emergency threatening the life of the nation, measures which derogate from Article 5 are permissible only to the extent strictly required by the exigencies of the situation, and it is for the derogating state to prove that this is so. The reasons given by SIAC do not warrant its conclusion. Just pausing there, you've seen from 44, the beginning of that paragraph on the previous page, that appeal from SIAC lay only on a point of law. But the reasons given by SIAC do not warrant this conclusion. The first reason does not explain why the measure is directed only to foreign nationals. The second reason, no doubt, has some validity. These are the reasons set out earlier in the paragraph, the third and the fourth. I do not consider SIAC's conclusion as one to which it could properly come. In dismissing the appellant's appeal, Lord Wolfe broadly considered it was sensible and appropriate for the Secretary of State to use immigration legislation. Others agreed. Chadwick regarded SIAC's finding as one of fact. I cannot accept this analysis as correct. The European Court does not approach questions of proportionality as questions of pure fact. See, for example, Smith and Grady. Nor should domestic courts do so. The greater intensity of review now required in determining questions of proportionality and the duty of the courts to protect convention rights would, in my view, be emasculated if a judgment at first instance on such a question were conclusively to preclude any further review. So would excessive deference in a field involving indefinite detention without charge or trial to ministerial decision. In my opinion, SIAC erred in law and the Court of Appeal erred in failing to correct its error. So you can see that in the discussion of proportionality, albeit not under the label of discrimination, Lord Bingham considered it relevant, opposite the letter B, that there was no explanation why the measures were directed only to foreign nationals, which is what I was trying to say about the crossover point. But he then, as my Lord Justice Singh rightly said, goes on to look at discrimination on its own merits and in its own right. And I don't need to take you to that for obvious reasons. But we do say it's significant, looking at what is said at the end of Lord Bingham's section on proportionality, that this was considered to be a decision to which SIAC could not properly come, notwithstanding the fact that the Court of Appeal had accepted it. So then going on to paragraph 73, so this is the last paragraph of Lord Bingham on 699, page 699. He allows the appeals, quashes the human rights derogation order and declares that Section 23 of the Anti-Terrorism, Crime and Security Act is incompatible with Articles 5 and 14 of the European Convention, insofar as it is disproportionate and discriminatory. So that was his speech. Lord Nichols, just briefly, at 81 on page 700. In the present case, I see no escape from the conclusion that Parliament must be regarded as having attached insufficient weight to the human rights of non-nationals. The subject matter of the legislation is the needs of national security. Substantial latitude to the legislature, but the human right in question, the right to individual liberty, is one of the most fundamental of human rights. Then at 85 on 701, he too would allow the appeals. He also used the word indefinite, but I think everyone uses that. Lord Hoffman, at 97, thinks the appeal should be allowed because there is no emergency threatening the life of the nation. And the famous dictum at the end about the real threat to the life of the nation coming not from terrorism but from laws such as these. But then above that, between C and D, he says, others of your lordships who are also in favour of allowing the appeal would do so on the grounds that a power of detention confined to foreigners is irrational and discriminatory. I would prefer not to express a view on this point. I would not like to give the impression that all that was necessary was to extend the power to United Kingdom citizens as well. That was the reason for his reticence. Then Lord Hope, 132 to 133, so we're going right forward now to page 714. This is an interesting paragraph on the crossover between discrimination and disproportionality. I would hold that the indefinite detention of foreign nationals without trial has not been shown to be strictly required, as the same threat from British nationals whom the government is unable or unwilling to prosecute is being met by other measures which do not require them to be detained indefinitely without trial. The distinction which the government seeks to draw between these two groups, British nationals and foreign nationals, raises an issue of discrimination, but as the distinction is irrational, it goes to the heart of the issue about proportionality also. It proceeds on the misconception that it is a sufficient answer to the question whether the derogation is strictly required that the two groups have different rights in the immigration context. So they do, but the derogation is from the right to liberty. That's the same for each group. And then 133, as Mr. Panic put it for liberty, I wonder if Lord Justice Singh was appearing with Mr. Panic.
I was.
Yeah. Section 23 of the 2001 Act is not rationally connected to the legislative objective. If the threat is as potent as the Secretary of State suggests, it is absurd to confine the measures intended to deal with it so they do not apply to British nationals, however strong the suspicion and however grave the damage it is feared they may cause. Also, the point that foreign nationals who present the same threat are permitted, if they can safely do so, to leave the country. Here, too, there is a clear indication that the indefinite detention of those who remain here as a means of countering the same threat is disproportionate. Then he goes on to look at discrimination, which, again, I don't need to take you to. Then Lord Walker, at the bottom of 732, paragraph 192, last few lines, of that page, safeguarding national security is, with the possible exception of some questions of macroeconomic policy and allocation of resources, the area of policy in which the courts are most reluctant to question or interfere with the judgment of the executive, or a fortiori, which of course is not an issue in this case, the enacted will of the legislature. Nevertheless, the courts have a special duty to look very closely at any questionable deprivation of individual liberty, measures which result in the indefinite detention of individuals who have not been tried, plainly invite judicial scrutiny of considerable intensity. And then he makes a point on the secrecy which necessarily attends most issues of national security, and the fact that a portentous but non-specific appeal to interests of national security can be used as a cloak for arbitrary and oppressive action on the part of the government. National security is the last refuge of the tyrant. And so on. But in the end, he does not agree with the others that it was disproportionate and discriminatory. And Baroness Hale at 219 agrees, and she says the others have really said everything that needs to be said, and Lord Carswell at 240 also agrees with Lord Bingham and with the others. So that's really what I wanted to take you to from Belmarsh. If we could go to tab 27, which is Bank Mellat, starting at page 1402. The report actually starts at 1339, but there's a previous judgment of the Supreme Court before we get to the judgments beginning at 1402, beginning with the judgment of Lord Sumption for the majority. At least there were substantive and procedural issues in this case, and we're interested in the substantive one. He says at paragraph 2, the proliferation of nuclear weapons is an international issue of great importance to the security of the United Kingdom and the international community. For a number of years, Iran has had a major industrial program which the United Kingdom, along with the rest of the international community, believes to be directed to the development of technical capability to produce nuclear weapons and to the improvement of its ballistic missile capabilities. So pretty high stakes. And then at paragraph 4, he brings in the power that was used in this case, section 62 of Counter-Terrorism Act of 2008, which empowered the Treasury to make a direction by a statutory instrument in specified situations involving 3 categories of risk associated with a foreign country, and there were risks arising from terrorist financing, money laundering, and nuclear proliferation. Paragraph 1.4 imposes a statutory condition: the Treasury have reasonably to believe, so not suspect but believe, that the development or production of nuclear, radiological, biological, or chemical weapons, or the doing of anything that facilitates such things, poses a significant risk to the national interests of the United Kingdom. Paragraph 5, if those conditions on relevant risk are satisfied, the Treasury may give a direction to one or more persons operating in the financial sector, regulating their dealings with any designated person. And a designated person includes any person carrying on business in or resident or incorporated in the foreign country in question. And it spells out what the direction may require, enhanced customer due diligence, enhanced monitoring, systematic reporting. But the kicker was paragraph 13. The direction may require those to whom it is addressed not to enter into or to continue to participate in any transactional business relationship with a designated person. And it was that was applied to Bank Mellat, and that which resulted in the termination of their business in London, $25 million a year. Just to complete that story, over the page at 1404, the paragraph 7, the order came into force in October. It was made under paragraph 13. It required all persons in the financial sector not to enter into any transactional business relationship with Bank Mellat or any of its branches, or with a shipping line, an Iranian-owned shipping line. And the present proceedings in paragraph 10, Bank Mellat had a procedural ground and a substantive ground. The procedural ground was failure to give the bank an opportunity to make representations. The substantive grounds at the start of 1405 are that the decision was irrational, disproportionate and discriminatory, that the Treasury failed to give adequate reasons for making it, and that their reasons were vitiated by irrelevant considerations or mistakes of fact. High Court dismissed the application, the Court of Appeal dismissed the appeal unanimously in the case of the substantive grounds. But the Supreme Court reversed that. So, under the heading of Treasury's reasons, the point is made at 11 that Bank Mellat was the only Iranian bank to have been designated under Schedule 7, despite the fact it was only part of the Iranian banking sector. I won't take you through the detail of this, but between E and F, you can see at the time of the Treasury direction, some of the Iranian banks with banking subsidiaries in the United Kingdom were restricted under other legislation. And, for example, Bank Separ was covered by an asset freeze. Bank Melli was covered by an asset freeze. And that was extended to not only to Bank Mellat and PIB, which is Persia International Bank, but to Bank Saderat as well. And this left among banks with a UK presence only Bank Tejerat, which was finally brought within the EU asset freeze sometime later. It's abundantly clear that the reason for singling out Bank Mellat from other Iranian banks was that it had been identified as having assisted Iran's weapons programs by providing banking and financial services to entities involved with them. And there was an explanatory memorandum saying these restrictions are being imposed in respect to these entities because of their provision of services for Iran's ballistic missile and nuclear programs. Considered that a direction to cease business with these entities will contribute to addressing the risk to the UK national interests posed by Iran's proliferation activities. And the document continued, second paragraph, of the particular entities in question, Bank Mellat has provided banking services to a UN-listed organisation connected to Iran's proliferation-sensitive activities, been involved in transactions relating to nuclear and ballistic missile programme. The direction to cease business will therefore reduce the risk of the UK financial sector being used unknowingly or otherwise to facilitate Iran's proliferation-sensitive activities. So, paragraph 19, we come to the bank's substantive grounds in the judgment of Lord Sumption. The bank now accepts that the statutory prerequisites for the making of the direction were satisfied. In other words, the Treasury reasonably believed that Iran's nuclear and ballistic missiles programs posed a significant risk to the national interests of the United Kingdom. But that's not enough to justify the order. At the bottom of that paragraph, it follows that the essential question raised by the bank's substantive objections to the direction is whether the interruption of commercial dealings with Bank Mellat in the United Kingdom's financial markets bore some rational and proportionate relationship to the statutory purpose of hindering the pursuit by Iran of its weapons programs. And here we get into Lord Sumption's, as I said, canonical formulation of the proportionality test. And he said the requirements of rationality and proportionality inevitably overlap. He deals with De Freitas and then the development of the case law through Daly, Shaler, Huang, and agia kila, and then says their effect can be sufficiently summarised for present purposes. This is the classic formulation, by saying that the question depends on an exacting analysis of the factual case advanced, and as we shall see, that is certainly what Lord Sumption went on to perform in defence of the measure, in order to determine, one, whether its objective is sufficiently important to justify the limitation of a fundamental right. That is not contested in this case, as any more than it was in Bank Mellat, as I said. 2, whether it is rationally connected to the objective. 3, whether a less intrusive measure could have been used. And 4, whether, having regard to these matters and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. These 4 requirements are logically separate, but in practice they inevitably overlap, because the same facts are likely to be relevant to more than one of them. And again, one certainly sees that from various formulations in this judgment. Before us, the only issue about them concerned 3, since it was suggested that a measure would be disproportionate if any more limited measure was capable of achieving the objective. For my part, I agree with the view expressed by Lord Justice Maurice Kay, that this debate is sterile in the normal case, where the effectiveness of the measure and the degree of interference are not absolute values, but question of degree, inversely related to each other. The question is whether a less intrusive measure could have been used without unacceptably compromising the objective. Lord Reid takes a different view on the application of the test, but there is nothing in his formulation of the concept of proportionality, which we'll also look at, which I would disagree with, and Lord Reid says very much the same about Lord Sumption's formulation. None of this means that the court is to take over the function of the decision-maker, least of all in a case like this one. This case lies in the area of foreign policy and national security, which would once have been regarded as unsuitable for judicial scrutiny. The measures have been opened up to judicial scrutiny by the express terms of the Act because they may engage the rights of designated persons or others under the ECHR. Even so, any assessment of the rationality and proportionality of a direction must recognise that the nature of the issue requires the Treasury to be allowed a large margin of judgment. It is difficult to think of a public interest as important as nuclear non-proliferation. The potential consequences of nuclear proliferation are quite serious enough to justify a precautionary approach. Then at the bottom, for my part, I wholly endorse the view of Lord Reid that the making of government and legislative policy cannot be turned into a judicial process. Nonetheless, there are, as it seems to me, 2 serious difficulties about the conclusion of the courts below. The first is that it does not explain, let alone justify, the singling out of Bank Mellat if, as both courts below agreed, the problem is a general problem of international banking. The second is that the justification for the directive which they have found was not the one which ministers advanced when laying the direction before Parliament, and was in some respects inconsistent with it. And what he then does at 23 to 24, and I shall spare your lordships a reading of them, but what he does there is he goes deep into the facts, he scrutinises the primary evidence, and he forensically dissects the reasoning of the first instance judgment and of the Court of Appeal. Then at 25, he comes to the issue that we saw Lord Hope address in the previous case, Belmarsh, at paragraph 132, the overlap, if you like, between discrimination and proportionality. A measure may respond to a real problem, but nevertheless be irrational or disproportionate by reason of its being discriminatory in some respect that is incapable of objective justification. And then he cites the Belmarsh case, and he cites at the bottom of that paragraph the passage from Lord Hope that I took you to just a moment ago. Then 26 is interesting. Every case turns on its own facts. Suppression of terrorism and prevention of nuclear proliferation are comparable public interests, but the individual right to liberty engaged in Belmarsh can fairly be regarded as the most fundamental of all human rights, other than the right to life and limb. The right to the peaceful enjoyment of business assets, protected by Article 1 of the First Protocol, is not in the same category of human values, but the principle is not fundamentally different. That's what I meant when I said that the rights at issue were comparable in these cases. We accept the intrusion is not as serious as the detention that was at stake in Belmarsh, but equally there are Article 8 interests engaged here as well as Article 1 of the First Protocol. We say that Mr. Shvidler's interests are at least as important as those of the bank, and in any event, Lord Sumption is saying the principle is not sufficiently different. At 27, I would not go so far as to say that the direction in this case had no rational connection with the objective as frustrating as far as possible Iran's weapons programs. On the footing that a precautionary approach is justified, the elimination of any Iranian bank from the United Kingdom's financial markets may well have added something to Iran's practical problem in financing transactions according with those programs, just as the incarceration of some potential terrorists under Part 4 of the Anti-Terrorism, Crime and Security Act may have made some difference to the reduction of terrorism. I think that the distinction between Bank Mellat and other Iranian banks, which was at the heart of the case put to Parliament by ministers, was an arbitrary and irrational distinction, and that the measure as a whole was disproportionate. This is because once it is found that the problem is not specific to Bank Mellat, but an inherent risk of banking, the risk posed by Bank Mellat's access to those markets is no different from that posed by the access which comparable banks continue to enjoy. Moreover, the discriminatory character of the direction must drastically reduce its effectiveness as a means of impeding the Iranian weapons programs. As the Exchequer Secretary herself pointed out, as long as all financial sanctions and relevant risk warnings are complied with, alternative banks may be used. Nothing in the Treasury's case explains why we should accept that it is necessary to eliminate Bank Mellat's business in London in order to achieve the objective of the statute, if the same objective can be sufficiently achieved in the case of comparable banks by requiring them to observe financial sanctions and relevant risk warnings. It may well be that other Iranian banks have not been found to number among their clients entities involved in nuclear and ballistic missile programs. It follows from the fact that this is a problem inherent in the conduct of international banking business that they are as likely to do so as Bank Mellat. The direction was irrational in its incidence and disproportionate to any contribution which it could rationally be expected to make to its objective. And I conclude that it was unlawful. Because if we go on to Lord Reid, he dissented on the substantive grounds of challenge, but where the legal analysis is concerned, we say that he was very much in line with what Lord Sumption had to say. If we go to 1427, this is where he starts on the substantive grounds of challenge. He says he's largely in agreement at 65 with Lord Sumption as to the relevant legal principles, other than in relation to two matters. We differ only in relation to the application of the law to the facts. Then he said he had something to say about the concept of proportionality, and that begins at 68, which I don't take you through, and he goes all the way back to Aristotle, via Aquinas and Blackstone, and I don't think we need read all that, at least I don't need to read it to you, but at 72, the approach to proportionality adopted in our domestic case law under the Human Rights Act has not generally mirrored that of the Strasbourg Court. In accordance with the analytical approach to legal reasoning characteristic of the common law, a more clearly structured approach has generally been adopted, derived from case law under Commonwealth constitutions and bills of rights, in particular the Canadian Charter. And then there's some discussion of that, the significance of the judgment of Chief Justice Dixon in Canada in the Oakes case. And then at the very bottom of 1429, he says the approach adopted in Oakes can be summarised by saying that it's necessary to determine, and here he has four ingredients of the test: whether the objective is sufficiently important, whether the measure is rationally connected to the objective, whether a less intrusive measure could have been used without unacceptably compromising the achievement of the objective, and then fourthly, whether balancing the severity of the measure's effects on the rights of the person to whom it applies against the importance of the objective, to the extent that the measure will contribute to its achievement, the former outweighs the latter. And he says where he got those from, and he says, I've formulated the fourth criterion in greater detail than Lord Sumption, but there is no difference of substance. In essence, the question at step 4 is whether the impact of the rights infringement is disproportionate to the likely benefit of the impugned measure. And at the bottom, 76, in relation to the fourth criterion, there is a meaningful distinction to be drawn between the question whether a particular objective is in principle sufficiently important in justifying limiting a particular right, step 1, and the question whether, having determined that no less drastic means of achieving the objective are available, the impact of the rights infringement is disproportionate to the likely benefits, step 4. So that is his analysis of...
Oh, sorry, could I just invite you to read paragraph 71? Don't need to read it out, but just for your full completeness, you'll see what he says in 71.
Yes, well, no dispute about that. He's saying it inevitably involves a value judgment at the stage at which a balance has to be struck. Doesn't entitle the courts simply to substitute their own assessment for that of the decision maker, and the intensity of review varies according to the nature of the right at stake and the context. And then the point that Strasbourg is sometimes less well placed than a national court to decide, and that concept of margin of appreciation does not apply in the same way at the national level, where the degree of restraint practiced by the courts will depend on the context. and will in part reflect national traditions and institutional culture. In other words, he's saying there isn't a knee-jerk culture of deference in our law consequent on the international nature of the Strasbourg court. It's contextual. And that's the justification for saying that we don't look at proportionality in exactly the same way as the Court of Human Rights.
At paragraph 75,
Yes.
Reid is referring to the Canadian case law.
Yes.
And indeed American case law, and recognises that even in those systems, they allow a margin of appreciation, a margin of discretion, whatever precise phrase one uses.
Yes.
And you wouldn't disagree with any of that, would you?
No, of course not. No. And the court is not the primary decision maker. Absolutely.
Yeah.
No.
So the first point you make is you're not submitting, contrary to what the judge below may have thought, that the court is the primary decision maker.
I hope he didn't think I was submitting that.
All right, well, leave aside what he thought.
Yes.
You're not submitting.
No.
That's an answer
No.
to the question, what is the appropriate test which the court has to apply? The fact that it's not the primary decision maker you submit doesn't tell us what is the test.
No.
And the test is to be found in bank mellat,
Yes.
you say.
Yes.
But do you accept that in applying that fourfold test, there is still scope for a margin of discretion, judgment, appreciation, however one
Well,
puts it?
undoubtedly, and we would say that that is at its strongest in relation to the first element of the test, because it's very unlikely, just as it was in the Bank Mellat case, that any court is going to second guess the judgment of the Foreign Secretary as to whether it is important to inhibit the Russian war in Ukraine. I mean, that is a matter of foreign policy. A court would be very rash to.
But what about the other parts of the fourfold test? Do you accept that there is, depending on the context, that there is room for a margin of judgment to be afforded to the primary decision maker?
Yes, and the first point is that the court itself has to assess the proportionality. It's not enough to
Yes, I understand that.
Yes,
Yeah, so
the issue is the standard of review.
Right.
And we say the judge fell into error by the we say false dichotomy that he put down between, on the one hand, primary decision maker, and on the other hand, was it within the range of reasonable responses to which a decision maker could have come, which is a very hands-off approach.
You say that's Wednesbury.
Well, it sounds a bit like Wednesbury. I don't think he called it that.
No, but on analysis, your submission
sounds
is that he was actually applying a Wednesbury.
Yes, and when you look at the way, for example, on rational connection, various connections will come to that was suggested between this designation and the objectives of the regulation, you see a very, very high degree of deference, not just in what the court is saying, but in what the court is doing. And we certainly contrast that with the approach you see from Lord Sumption in the Bank Mellat case. In those paragraphs so detailed, I didn't read them out to you, but 23, 24, where he's really getting the decision maker by the scruff of the neck.
But Lord Anderson,
Yes.
How do you say you allow a margin of appreciation to the three questions, particularly the balance, if you're taking your own decision on those four questions as a court? So how do you do the exercise of allowing a margin of appreciation whilst taking your own decision on the tests? What's the process?
Well, I mean, I'll take that, if I may, from, you've seen what Lord Sumption says, and I'll show you also what Lord Reid says, which we think is also helpful guidance on that. In relation to whether it's margin of appreciation, I'm never quite sure about the terminology in this area. It keeps changing. I think margin of appreciation is really a term that one accords to the Strasbourg.
It's an international doctrine.
Yes, and you saw the explanation in the paragraph that learned friend helpfully asked me to read about how that is influenced by the fact that it is an international court. And that's why in our jurisdiction we're able to be more intrusive, because although the courts have the caution that is natural to courts, they don't have the additional layer of caution that is added by being international, and therefore perhaps being less familiar with conditions in the various states that subscribe.
You see, what Lord Reid says is that it will all depend on the context and will in part reflect national traditions and institutional cultures. And for these reasons, the approach adopted to proportionality cannot simply mirror that of Strasbourg. Fair enough. But I'm just asking for something a little more concrete to hang my hat on.
Yes, well, I understand that. Can I?
Comes back to the simple
Yes.
private lawyer, really.
Well, yes. May I finish with Lord Reed and see if
Yes.
Your Lordship's any happy?
Well, we're in Lord Reed, aren't we? And we've
We are
got
in Lord
76.
We are in 76. And then if we move on, we get to applying the proportionality test in paragraph 83, where he addresses rational connection beginning at 92, again by reference to Canadian law. He considers the Belmarsh case, which at 97 he says he spent some time considering the basis for that decision in order to clarify what the case did not decide. It wasn't decided, he said, on rational connection grounds, because the legislation in that case would have made a contribution to the achievement of its objective, so it might have kept us a bit safer from terrorism. Secondly, the case did not decide that the legislation lacked a rational connection because it was discriminatory. The difference in treatment was relevant to proportionality because it bore on the question whether the interference of the rights of the foreign suspects had been shown to be necessary. So that's what Lord Sumption described as overlapping considerations. He was analysing A to see which one was applied. Then on the facts, he is unable at 1439G. He also analyses the reasoning of the Treasury as accepted by Mr. Justice Mitting and by the Court of Appeal at 108, 109, 110. In the circumstances, I'm unable to agree with Lord Sumption's statement that Mr. Justice Mitting's finding about mellat's procedures suggests they were satisfactory at any rate in relation to the weapons programmes. So the court may not be the primary decision maker, but here you have the Supreme Court coming to their own view on whether Bank Mellat's procedures were satisfactory in relation to weapons programmes. And it happened that these two judges came to different conclusions on it. That was the level that they were getting to. And then Mr. Justice Mitting did not regard these matters as undermining the Treasury's case, but says the Treasury's case is not the bank as knowingly assisted, or even that its knowingly assisted entity is liable to be designated, but that it has the capacity to do so, has in one instance done so and is likely to do so in the future. The fundamental justification for the order is that even as an unknowing and unwilling actor, the bank is by reason of international reach well placed to assist entities to facilitate the development of nuclear weapons. Lord Sumption at 112 says that's an arbitrary and irrational distinction. Lord Reed doesn't agree, and he talks about the lack of adequate controls within Iran's banking system, identified by the FATF, and so on, 113, 114. And he concludes, 115, that the order directed specifically against Bank Mellat was far from being pointless or arbitrary. And one effect of it was to prevent the only UK subsidiary of an Iranian bank not already subject to controls from dealing with its parent, Bank Mellat. There was some argument about that, because Sumption also looked at that issue. 116, it is of course true that the direction would not of itself prevent the development of nuclear weapons in Iran. It could, however, reasonably be expected to realise the objective of hindering their development, at least to some extent, to adopt Lord Neuberger's phrase, that is sufficient to establish a rational connection. So I don't seek to interest your lordships in who's right and who's wrong about the outcome of that analysis, but I do seek to draw to your lordships' attention, the care with which that analysis was carried out by both judges. Then at 118, a separate point made by Lord Sumption is that the justification for the making of the order was not the one which ministers advanced when laying the order before Parliament. It was in some respects inconsistent with it, and he thinks that point is not well founded in fact, and he explains that over the next paragraphs. 125, he comes on to less intrusive means.
Is the quotation from Huang at 124 of assistance?
The task on an appeal on a convention ground against a decision of the primary decision maker is to decide whether the challenged decision is unlawful as incompatible with the convention right, or compatible and so lawful. It is not a secondary reviewing function dependent on establishing that the primary decision maker misdirected himself or acted irrationally or was guilty of procedural impropriety. Lord, yes, and I hope that goes some way to answering the question of the Master of the Rolls. And that is implicitly at least endorsed by Lord Reid. Then, less intrusive means at 125. Lord Sumption concludes the direction also fails the proportionality test at the third stage of the analysis. So this was after rational connection. We go on to less intrusive means on the basis that it cannot be necessary to require UK financial institutions to cease dealing with bank mellat if less drastic measures are considered to provide sufficient protection in relation to other Iranian banks. And then he thinks they're not truly in a comparable position, attaches importance to the evidence of Mr. Robertson that the Treasury considered but rejected less intrusive measures. In a matter of this kind, great weight must be given to the considered judgment of the Treasury. Against that background, I accept Mr. Justice Mitting's conclusion there is no other reasonably practicable means of ensuring that the facilities of an Iranian bank with international reach will not be used in the UK for the purpose of facilitating development of nuclear weapons by Iran. And then, once again, he has a disagreement with Lord Sumption on proportionate effect. So they've gone through all of the last three elements of the test, and he doesn't agree that the direction would make little, if any, contribution to the achievement of its objective. He notes...
the quote from Wang deals with the task of the appeal court, or the court on appeal, but it doesn't deal with the question of how you pay deference, how you square the circle of taking your own decision, which it makes clear you have to do, but whilst also allowing some deference or some margin of appreciation to the decision maker. And I mean, I like searching documents, and I can't find deference or defer or find what he said about it.
I wonder if paragraph 129 may be helpful in that regard.
Yeah, thank you.
Yes, I wish I could give your Lordship a neat little list of the areas in which the court will apply particular degrees of deference. I mean, my sense is that in the United States, the Congress is sometimes induced to legislate on that basis, so that the courts know in advance what degree of deference they are supposed to exercise. But as I understand the case law in this jurisdiction, it is highly contextual. And 129, as Lord Justice Singh says, does give an indication that where the court does not possess expertise or experience in specific areas, and the court has to attach considerable weight to the government's assessment.
So if you were talking about is this measure, I've forgotten the right word, but relevant, useful,
yeah,
one would attach more deference to the government's view on that, because the court has very little way of knowing whether it's useful to affect Mr. Putin's actions, one guesses in this case. Not sure how the court would evaluate that. But if you were deciding a balance, well, you might you pay less regard? I mean, I'm asking.
Yes, well, yes. I mean, that's why we don't seek to suggest to the court that the first limb of the test was not satisfied. We're certainly not seeking to argue with the Secretary of State about that, about the importance of the objective. But if, particularly in a case like this, where what you see is what you get, the government have told us that when you come to rational connection, they formulated their case on that on the basis of the documents that we have seen. And judges, we say, are very well equipped to follow a logical chain of analysis, or follow a chain of analysis and see whether actually it's logical and whether it stacks up. And in a circumstance such as that, it's certainly something that the court can come in on, as both these judges demonstrated. And they both displayed great confidence in their ability to decide what might have been necessary or not necessary to prevent Iranian banks from being used by, or using British financial institutions to fund the Iranian missile program. So it will depend on the state of the evidence. It will depend, of course, on the subject matter and the nature of the expertise of the Secretary of State. Frankly, it may also depend to some extent on and this is why I took you to the DSARs and the way that this decision was made. It's a wonderful picture in my friend's skeleton of the wonderful tranquil procedure by which this decision was rationally arrived at, but when one knows how it was actually arrived at, and how the story of the revised designation was really a story of trying to defend what had already been said, that may also be an indicator that perhaps one doesn't give quite as much deference as one otherwise might to the thought processes of the decision maker. It's very unusual the way this designation came about.
But anyway, you say that the judge here was wrong because he was effectively saying this was within a range of rational decision making, and that's not the right test. But you're not going to give me an easy mantra as to how you apply the correct test, which is for the court itself to apply the four questions and to take into account some margin of appreciation for government depending on context. And presumably context here is if the government is peculiarly well informed about, for example, how effective the measure might be, then you would give more margin of appreciation to that. Whereas if it's simply a question of looking at the evidence the government has produced, the court's well equipped to do that for itself.
Mm. Well, let me try once more. Lord. Let me finish taking you through this case, not far to go. And then I might take you to the Lord Carlisle case, which is a couple of years later, and it's Lord Sumption's next attempt at explaining. And we'll see if there's anything more in there for your lordship. But certainly let me...
And perhaps the abortion, latest
and indeed the
abortion
abortion
case.
case. Those are indeed the next two
yeah.
cases I was going to take you to.
My lord, sorry, just before my learned friend moves on,
Yes.
and on a slightly separate point, the 124 paragraph that drew my Lord Justice Singh's attention as a potential indicator as the right approach for an appellate court might need a little bit of caution, because the appeal that is there being referred to is an appeal from the primary decision maker to a court.
That wasn't the point I was actually getting at. It's more that it's not the court's function simply to ask whether the primary decision maker misdirected himself, acted irrationally,
Yes.
or was guilty of procedural
Yes.
enterprise. I accept the context of Lang was that was an immigration appeal. That's why there's reference
Exactly.
to appeal.
Yes.
That's all.
And as the Lord said, when we get on to abortion services, we'll see something there about the function of the appellate court. So, similarly, on paragraph 125, on less intrusive means, he disagrees with Lord Sumption, but on the facts. And if we go finally to Lord Newburger at 168, that's how he explains the difference between the majority and the minority. He says the explanation for the fact that Lord Sumption and Lord Reid have reached opposing conclusions on Bank Mellat's substantive challenge largely lies in the difference between their respective analyses of the facts. Essentially, Lord Sumption concludes the Treasury's decision was legally flawed for two main reasons. No reason to single out Bank Mellat, and the ground is now different from that before. He doesn't find it at 172 easy to resolve the question of whether the substantive analysis should succeed. And he explains why that is. So I really just take you to that for his comment on the nature of the disagreement between the majority and the minority. But he too gets into the facts, and as he records at 195, so far as the facts are concerned, I have explained in paragraphs 170 to 174 why there is, in my view, considerable force in the bank's substantive challenge to the giving of the direction. The fact that the justification of the direction was not very strong, coupled with the more specific facts, the Treasury was wrong about the ownership and could usefully have discovered what steps the bank was taking, provides specific and practical support for the conclusion the bank should have been given an opportunity to make representative report as it was given. So that's on the procedural side. He finds a relationship between the substantive and the procedural sides. So the next case is the Lord Carlisle case. Begins at page 1461, tab 28. And as you see from the beginning of the head note, the first 16 claimants were members of the House of Commons or of the House of Lords. A number of them invited the 17th claimant, a dissident Iranian politician resident in France, to visit them in London to discuss issues concerning human rights and democracy in Iran. The claimant had been denied entry since 1997 on the ground that her exclusion was conducive to the public good, but the Home Secretary maintained her exclusion, and then held one, that where convention rights were adversely affected by an executive decision, the court was obliged to form its own view of the proportionality of the decision, that although proportionality was ultimately a matter for the court, that did not entitle it to substitute its own decisions without a primary decision maker, or simply to frank the decision without itself considering it. The degree of restraint to be exercised by the court and the extent to which the assessment of the primary decision maker would be respected depended on the context. Where the decision was based on factors where the court did not have the evidence, experience, and institutional legitimacy to form its own view with confidence, its interference could only be justified in exceptional circumstances. Issues as to the likely adverse reaction of a foreign state and potentially harmful effects on the safety of individuals and economic and diplomatic interests were matters which, as a matter of constitutional settlement, which were entrusted to the executive, which had specialised experience, a wide range of source material and institutional competence. Accordingly, great respect was accorded to such decisions. But then, going to the substance of Lord Sumption's judgment, and starting at paragraph 30 on page 1485, he talks about the traditional treatment of foreign policy or national security decisions depending on the non-justiciability of the Crown's prerogative. It cannot apply in cases where scrutiny of such decisions is necessary in order to adjudicate on a complaint that convention rights have been infringed. Nothing which is relevant can be a forbidden area, although complaints about the substance may well be met by the response that it's not relevant. He doesn't like the phrase merits review because he finds it unclear, but he says that when it comes to reviewing the compatibility of executive decisions with the convention, there can be no absolute constitutional bar to any inquiry which is both relevant and necessary to enable the court to adjudicate. None of this means that in human rights cases a court of review is entitled to substitute its own decision for that of the constitutional decision maker. However intense or exacting the standard of review in cases where convention rights are engaged, it stops short of transferring the effective decision-making power to the courts. Nor as a general rule, Corner House is cited, nor as a general rule does the jurisprudence of the Strasbourg Court require that administrative decisions should be subject to an appeal on the merits, especially where based on grounds of expediency and so on. But the obligation of the courts to adjudicate on the alleged infringement of convention rights does mean that the traditional reticence of the courts about examining the basis for executive decisions in certain areas of policy can no longer be justified on constitutional grounds. Rather different considerations apply where the question is not what is the constitutional role of the court, but what evidential weight is to be placed on the executive's judgment, a question on which the human rights dimension is relevant but less significant. It does not follow from the court's constitutional competence to adjudicate on an alleged infringement of human rights that it must be regarded as factually competent to disagree with the decision maker in every case, or that it should decline to recognise its own institutional limitations. In the first place, although the Human Rights Act requires the courts to treat as relevant many questions which have previously been immune from scrutiny, including on occasions the international implications of an executive decision, they remain questions of fact. The executive's assessment of the implications of the facts is not conclusive, but may be entitled to great weight, depending on the nature of the decision and the expertise and sources of information of the decision maker or those who advise her. Secondly, rationality is a minimum condition of proportionality, but it is not the whole test. Nonetheless, there are cases where the rationality of the decision is the only criterion which is capable of judicial assessment. This is particularly likely to be true of predictive and other judgmental assessments, especially those of a political nature. Such cases often involve a judgment or prediction of a kind whose rationality can be assessed, but whose correctness cannot in the nature of things be tested empirically. Thirdly, where the justification depends on judgment about the future impact, there is not necessarily a single right answer. There may be a range of judgments which can be made with equal propriety, in which case the law is satisfied if the judgment under review lies within that range. And they cite the present case. And then there may be some cases where there is an expectation that in a democracy a person charged with making assessments of this kind should be politically responsible for them. Ministers are politically responsible, judges are not. All those points were made by Lord Bingham in the Belmarsh case, and paragraph 29 is cited from there. If we could go on, and this perhaps is as close as I'm going to get to answering.
Well, that's what I was going to say, was that's as close as you might get.
Well, no, we do better.
Question.
We do better, my lord. Paragraph 34.
Oh, good.
Right. Various expressions have been used in the case law to describe the quality of the judicial scrutiny called for when considering the proportionality of an interference with a convention right. Heightened, anxious, exacting, and so on. These expressions are necessarily imprecise because their practical effect will depend on the context. In particular, it will depend on the significance of the right, the degree to which it is interfered with, and the range of factors capable of justifying that interference, which may vary from none at all, as in torture, to very wide-ranging considerations indeed. Privacy. But the legal principle is clear enough. The court must test the adequacy of the factual basis claimed for the decision. Is it sufficiently robust, having regard to the interference with convention rights which is involved? And we highlight that as an answer to your lordship. It must consider whether the professed objective can be said to be necessary in the sense that it reflects a pressing social need. It must review the rationality of the supposed connection between the objective and the means employed. Is it capable of contributing systematically to the desired objective? Or its impact on the, I think that must be, or is its impact on the objective arbitrary? Again, we rely on that. The court must consider whether some less onerous alternative would have been available without unreasonably impairing the objective. That too. The court is the ultimate arbiter of the appropriate balance between two incommensurate values, the convention rights engaged and the interests of the community relied on to justify interfering with it. But the court is not usually concerned with remaking the decision-maker's assessment of the evidence if it was an assessment reasonably open to her, nor on a matter dependent on a judgment capable of yielding more than one answer is the court concerned with remaking the judgment of the decision-maker about the relative advantages and disadvantages of the course selected, or of pure policy choices, e.g. do we wish to engage with Iran at all. The court does not make the substantive decision in place of the executive. On all these matters, the court is entitled to attach special weight to the judgments and statements of a primary decision-maker with special institutional competence. Well, I think that's as good as I can do from this case. And we say paragraph 34 expresses it very well, with obvious respect. Then the abortion services case, it's tab 44 of the authorities, page 1994. And in this case, Lord Reid gave the single judgment. I'm sorry, tab 44. Lord Reid gave the single judgment for a 7-judge court. I just want to take you really to the section from paragraphs 30 to 32, so page 2015. He says at 29 that in the first place, questions of proportionality, particularly when they concern the compatibility of a rule or policy with convention rights, are often decided as a matter of general principle, rather than an evaluation of the circumstances of each individual case. And we say, well, that is not the question here. We're not looking at the proportionality of the sanctions regime as a whole. We're looking at its application to an individual. At 30, those cases also demonstrate the related point that the determination of whether an interference with the convention right is proportionate is not an exercise in fact-finding. It involves the application in a factual context, often not in material dispute, of a series of legal tests set out at paragraph 24 above, together with a sophisticated body of case law, and may also involve the application of statutory provisions or the development of common law. And then he cites Lord Bingham and Belmarsh. With the agreement of the majority of a 9-member appellate committee, the European Court does not approach questions of proportionality as questions of pure fact, nor should domestic courts do so. That is reflected in the approach adopted by this court to appeals on questions of proportionality. So now we're on the role, from a friend's point, on the role of the appellate jurisdiction, indeed the Supreme Court. In cases such as those cited in the previous 2 paragraphs, the court, or in the Belmarsh case, the House of Lords, did not accord any deference to the assessment of proportionality by the courts below, or limit its review to an assessment of the rationality of their conclusion, but carried out its own assessment. The same is true of other appeals concerned with rules or policies in which the facts of the individual case were of greater significance. And again, Bank Mellat is referred to, in which Lord Reid and Lord Sumption engaged in just such an exercise, albeit they came to different conclusions. That also reflects the related fact that the judicial protection of statutory rights by appellate courts is not secured merely by review according to a standard of unreasonableness. And this is appellate courts. Nor does such a restricted review meet the requirements of the Convention, as this court and the House of Lords before it have pointed out on many occasions. See, for example, the Belmarsh case, where Lord Bingham referred to the greater intensity of review now required in determining questions of proportionality. And Lord Justice Singh referred to the Smith and Grady case, which set us right on that.
Is paragraph 33 of importance? Because we often have cited to us and I think we have cited to us in this case, in this appeal. Cases such as the R case, which is Lord Carnworth, and Lord Reed deals with R, he deals with re B, I guess letters B and C and D on the next page. I just wonder if you could help us, please, Lord Anderson, on that passage.
Yes, well, of course, this case followed the Ziegler case,
Yes.
in which, as he says at 33, the majority of the court treated issues of proportionality as being susceptible to appeal by way of case stated, only on the basis that if an error of law was apparent on the face of the case, or if no reasonable court properly instructed as to the relevant law could have reached it. And he says that Lord Hampden and Lord Stevens interpreted in re B in the light of a dictum in R as meaning that appellate courts should adopt a standard of unreasonableness when considering issues of proportionality. And then he says re B was concerned with the proportionality of a specific case order in the circumstances.
Care order.
Specific care order in the lights of the circumstances of a particular child, a one-off decision which the judge who heard the evidence was particularly well placed to take. The approach adopted by this court was that the appellate court should intervene if the lower court's assessment of proportionality was wrong. That approach is capable of being applied flexibly, since the test or standard applied in deciding whether a decision is wrong can be adapted to the context, as Lady Arden noted in Ziegler, and as Lord Sales emphasised in his judgment. The case of R was a judicial review concerned with the disclosure of particular information about an individual's past in an enhanced criminal record certificate. Lord Carnworth followed in re B, but added the observation cited by Lord Hampden and Stevens that for the decision to be wrong, it is not enough that the appellate court might have arrived at a different evaluation. But then, it would, however, be a mistake to attach undue significance to a statement which was made by Lord Carnworth in the context of a particular case, without reference to a plethora of other cases, some of which have been mentioned in paragraphs 29 to 31 above, in which a more interventionist approach was adopted by this court in order to enable it to fulfil its constitutional function and to perform its duty under the Human Rights Act. So, Lords, it's elegantly done, but that's the unanimous 7-judge Supreme Court last year. So I put that together with the Lord Carlisle case, and I'd hope that Lordship have the guidance there that you need, while I entirely accept that these issues are context-specific, and therefore it's important to look not just at what the judge said in this case, but at what the judge did. And with that in mind, Lord, can I begin with a submission on arbitrariness? And as your Lordships know, we were refused permission to run discrimination as an independent ground. I'm afraid, on the basis of a misunderstanding by Lord Justice Lewis, which I will explain to the court in a moment, that the substance of the point remains relevant to our submission. The designation of Mr. Shvidler was arbitrary and disproportionate, and we explain that in paragraph 63 of our skeleton, as well, in fact, as we explain it in our grounds of appeal. So we've always accepted that they interrelate. And you will recall Lord Hope in Belmarsh, paragraph 132 on the overlap, Lord Sumption in Bank Mellat, paragraph 25, the first and last sentences citing Lord Hope. Can I just show your Lordships how we put the point in our grounds? It's at the core bundle, tab 14. At page 205, well, sorry, it begins actually at 204, which is where the ground of discrimination is introduced. And the point is made at 56 that the claimant resigned as a non-executive director on the day Mr. Abramovich was designated, 2 weeks before he was designated.
Sorry, I haven't got the right page.
Sorry, my lord, page 205 of the core bundle.
Thank you.
9 other members of the board resigned on the same day. Until 2nd November, Mr. Shvidler was the only board member to have been designated on the basis of his role with Evraz. And then on the 2nd of November 2022, Mr. Abramov and Mr. Froloff were designated. 5 board members, former board members of Evraz, many of whom were board members for as long as Mr. Shvidler and earned more in their positions as non-executive directors, have not been designated. The only board members sanctioned by reason of their role on that board are of Russian ethnicity. None of the non-Russian members have been designated due to their membership of the board. This is a difference in treatment of persons in analogous or relevantly similar situations on the grounds of ethnicity without apparent justification, and no response was provided. Then we say at 58, it's submitted that given the Secretary of State's assertions as to the imperative need for the designation of the claimant and his 2 Russian former colleagues, the fact that treatment was only extended to those of Russian ethnicity demands an explanation, and as noted above, undermines the Secretary of State's assertions as to the necessity for such measures. Further, in the absence of any objective justification offered, this is a violation of the Human Rights Act. Any belated justification offered by the Secretary of State ought to be subject to stringent scrutiny. And all the signs that we are concentrating there on indirect discrimination are, first of all, the reference to objective justification, and secondly, the reference to the Independent Workers' Union case, the minicabs case, which I know that Master of the Rolls and Lord Justice Singh are very familiar with. Indeed, we cited what each of your lordships said in that case, which, as I understand it, by the time it came to the Court of Appeal, I should say Mr. Birdling was in the case too, was a case that depended on discrimination under the Human Rights Act.
I don't understand, I'm afraid, Lord Anderson, your submission about the relevance that there had to be objective justification, because in principle, unlike the domestic equality legislation, as I understand it, under Article 14, in principle, even direct discrimination is capable of being objectively justified. Perhaps not racial discrimination.
I had a very erudite note on the subject yesterday from Mr. Birdling, and it may be that if you were minded to invite him to address the lordships at the end of my submissions, it might be a subject on which he could usefully address a few words. But certainly there is a Strasbourg decision. I think I'll leave it to Mr. Birdling.
I think I know where the point is heading, but subject to my Lord's views, that may be helpful.
He can do it now if you like.
Well, should we do it at the end?
Yes.
Yeah.
I rather like the system of letting a tutor speak. Not to be said for it. Yes, that's the grounds. But regardless of whether you're with me or not on the point I make about indirect discrimination, the Independent Workers' Union is undoubtedly a case on indirect discrimination. And you remember the facts. It was, I think the great majority of black cab drivers were white, and the great majority of minicab drivers were not white. And that was described by Lady Justice Simler in that case as discrimination, though indirect in form, closely related in substance to the direct form of discrimination on grounds of national origins. So indirect discrimination can be justified, but the justification needed stringent scrutiny, as it indeed received in that case. And then the same thing in our skeleton argument before the court below. We relied on, I'll just take you to that, it's in the core bundle, tab 9, paragraph 71. So that is page 131. And there's a reference again to the minicab case, and also to the Sadich and Finchy case, which I had a look at this morning, and I thought there was a dictum in there to the effect that discrimination on grounds of race direct discrimination could never be justified. But
there is case law in Strasbourg which says that if it's race, then it can't be. But direct discrimination in principle can be, whereas in domestic legislation it can never be.
Yes, that's true. Yes. So there's a distinction Lordship is making between race on the one hand and ethnic origin on the other. Yes. Well. Yes. Well, Mr. Birdling thinks it's both. So it's not in the bundle anyway, but I will gratefully leave that issue to him. So that's what we said about it. In the judgment, if we look at 151 to 152, you see the reasons accepted by the learned judge for the differential treatment of the directors of different ethnicities. And I think I showed you this already, in fact, that it was the combination of the role with his relationship with Abramovich which put the appellant in a different category from Sir Michael Peat and the others, and no evidence that race, nationality, or ethnicity played a part in the defendant's decision-making. And similarly, it was a combination of relevant factors in the case of Messrs. Abramov, Frolov and Tenenbaum that led to their designation. Two of them were part of the arrangement that controlled the company. Mr. Tenenbaum was designated on the basis of his association with Mr. Abramovich. So the idea is that if you're associated with Abramovich, you get designated, and that is enough to take you over the line, whereas just being a non-executive director isn't. That's the objective justification.
Could it be said, Lord Anderson, that the difficulty you face in bringing this argument in on arbitrariness is that the judge has found that your case on this issue was hopeless. It proceeded on an inference without foundation, and you attempted to appeal against that part of his decision, but you were refused permission to do so. So, unlike Belmarsh, for example, we don't have a situation where the court is proceeding on the basis both that there is unlawful discrimination and therefore closely related to the arbitrariness point. Don't we have to approach the arbitrariness argument on the footing that there is an unappealable finding of fact that there was no unlawful discrimination?
What I'm saying about the judgment, I say there are two errors in it, but the error I would refer to in answer to Lordship's question comes at the end of 151. The judge misunderstood my submission. I mean, no doubt the fault was mine, but the judge proceeded on the basis that we had to find that ethnicity played a part in the defendant's decision-making. Well, with respect to the learned judge, we didn't. Our case was on indirect discrimination, so all we had to do was point to an imbalance in the treatment of those of different ethnicities, and then invite the court to scrutinise the justification. So with respect to the judge, he was pronouncing on a submission that we weren't making. And Lord, then the second misunderstanding or inconsistency on the part of the judge relates to objective justification, and it's in the distinction that the court sought to draw between the treatment of different directors based on their association with Mr. Abramovich. So you've seen the picture that Shvidler and Tenenbaum had an association and were sanctioned. The non-Russian origin directors had no such association and were not sanctioned. But that is contradicted by the government's own logic, which was accepted by the court, because the government's case was that all members of Evraz's board, whatever their ethnicity, were remunerated. And because Mr. Abramovich controlled the company, that meant that they all obtained a financial benefit from Mr. Abramovich and were thus associated with him. And that's what the government put forward in their skeleton argument below, core bundle paragraph 52. And if you look at the judgment at 104, the judge agreed with that. And he said, even if the argument based on Mr. Abramovich's nomination of the claimant were to be rejected, the claimant's remuneration as a director can properly be regarded as a financial benefit obtained from Mr. Abramovich. Well, if the claimant had a connection with Mr. Abramovich because he was remunerated as a director, then so did the directors that had English names. That's really the point we make on that. But Lord, our point on arbitrariness is not, for a start, there's never been a point on direct discrimination, nor is it limited to the issue of indirect discrimination, despite the fact that you take the overlap from the case of Lord Sumption and Lord Hope. The next element of it relates to lack of policy and guidance. And there was a remarkable absence of any policy or guidance governing the exercise of the very broad discretion to designate people, or indeed to de-designate people. And we made the point that, we already made the point today, that many thousands of people at least must fall within the scope of Regulation 6, including all these reputable directors of companies, members of their families, and if the government is correct in its reading of Regulation 6, their friends and their business associates. And we know that OFSI, the Office of Financial Sanctions Implementation, does have a policy in relation to basic needs licensing, so as to ensure a coherent and consistent approach. It may be very slow and cause enormous delays, but it does at least have a policy. And we put a reference to that at the end of the appeal skeleton, footnote 23, it's on page 38. But there is no such policy on the even more important matter of designation and de-designation. And I can take that from a letter that was written shortly before the High Court hearing and drawn to the attention of the High Court. It's in the supplementary bundle at page 347. This letter was written prompted by the de-designation of somebody called Mr. Cassis. I think he's one of the only 4 people who've been de-designated. And we were interested to know, pursuant to what policy or guidance document he'd been de-designated. And the government responds, this is just shortly before we went into court, very prompt response. You've asked for the disclosure of any policy or guidance documents relating to or informing the decision to de-designate Mr. Curtis. We can confirm there are no relevant policy or guidance documents, and that the decision to revoke Mr. Curtis' designation was not informed by any such document. Lords, we do not say that the absence of such a policy in itself renders all designations unlawful, but we do say that it is a relevant factor in the court's assessment of whether the designation of Mr. Shvidler was arbitrary and thus disproportionate. And I must take you to a couple of cases very quickly on that. The first is in the Authorities Bundle, tab 16, page 748, a case called B and Secretary of State for Work and Pensions, decision of the Court of Appeal.
Sorry, which tab is this?
Tab 16 of the First Authorities Bundle. It's just a short reference in the judgment of Lord Justice Sedley, but agreed with by both Sir Martin Norse and Lord Justice Buxton, where he says at the start of paragraph 43, it is axiomatic in modern government that a lawful policy is necessary if an executive discretion of the significance of the one now under consideration is to be exercised, as public law requires it to be exercised, consistently from case to case, but adaptably to the facts of individual cases. And we say that is no less true now than it was then. And indeed, if one looks at the DSARs and the circumstances in which the decision to designate was taken, it is hard to deny, we suggest, that the process would have been assisted, at least, by the presence of some guidance or policy that would have had to be applied. Then the second case, the very well-known case of Lumber in the Supreme Court, it's at tab 23 of the Authorities Bundle, and it's at paragraph 34 of that judgment, which is at page 1145. Now, of course, this was a case in which there were two sets of guidance. There was published guidance, and then there was secret guidance, which seemed to have a more or less opposite effect. But nonetheless, there is an interesting statement of principle by Lord Dyson at paragraph 34, where he says the rule of law calls for a transparent statement by the executive of the circumstances in which the broad statutory criteria will be exercised. Just as arrest and surveillance powers need to be transparently identified through codes of practice, and immigration powers need to be transparently identified through the immigration rules, so too the immigration detention powers need to be transparently identified through formulated policy statements. And if one proceeds with decisions of this magnitude and significance for the individual without the benefit of policy or guidance, well, one is not ipso facto acting unlawfully, but one is certainly putting oneself at risk of acting arbitrarily, we say.
But can you have a policy that applies to all situations of this kind? I mean, these things apply. These things happen very quickly, and you need to move fast. Presumably, you're going to have an effective response. Can you have a general policy that is going to apply in every case? What do you say? That you've got to do this or that, and then urgency. What happens if you're caught out by the urgency of the situation?
Yeah. I suppose it's partly what I was trying to say at the start about the remarkable lack of safeguards, really, in this whole system.
Well, that's a different point, really.
But in a sense, a published guidance or policy is a sort of a safeguard, in that it disciplines the decision maker. I suppose, like sentencing guidelines, they ensure that the sentencing judge is asking the right question, and of course, criminal cases occur in an unknowably wide variety of cases.
But you're not challenging the lawfulness of this legislation or the regulation.
No. Nor am I saying even that the absence of policy or guidance is enough to render all these decisions unlawful, but I'm saying that it is a factor which is conducive to the taking of arbitrary decisions, and that what we had in this case was an arbitrary decision.
Okay.
That's what I'm saying.
But it was arbitrary because others who could have been subject to the same treatment weren't. That's the essence of your arbitrariness argument.
No, that's not the only essence. And I would agree
quite a
that
lot of it. The other co-NEDs were not caught by the same provision. So you're back into sort of discrimination and lack of equal treatment, aren't you?
Well, that's certainly where I began my submission on arbitrary, and if you look at the Belmarsh case, that's really where it began.
Oh,
and
yeah,
ended,
I understand that.
as Lord Justice Singh said. But there are other aspects. I rely on the DSARs as the insight that they give into the way that the original decision came to be made, and I will rely in due course on the rational connections and the attempts to justify this designation on the basis of what we say are highly tenuous and indirect rational connections. I think all those things can feed into the assessment of arbitrariness and disproportionality. Finding,
I mean, I find this arbitrariness and discrimination point quite difficult, actually, Lord Anderson, because one can envisage a situation in which the government looks at the thing and says, well, X is well over the line, Y is a bit more borderline, and so we're going to let Y off the hook and not designate, but we're going to designate X and A and B. But it's all very much a matter of judgment and degree, fact and degree.
Yes.
And then the people who are designated come along and say, well, you can't, you've discriminated against me because you haven't designated this person who has facts quite similar, but not exactly the same, never be. And that puts surely the decision maker in quite a difficult position if it can be said that it's arbitrary, if you've left out anybody who could otherwise have been sanctioned, because you might, for example, have decided, well, it would be excessive to sanction more than, say, 200 people. I mean, I'm just picking a number out of the air. So we're going to do the ones we think look the most egregious, but we can't be sure we're right, because, of course, the facts are not always clear. I mean, it's putting the government in quite a difficult position, isn't it?
well, I would submit it would actually be putting it in an easier position, because, of course, we're not suggesting an algorithm. We're not suggesting a computer.
That might be the answer, actually.
I think not.
Certainly
I hope
one
there's
that
still
would,
room for the human being.
certainly one that would appeal to me.
Oh, well, if anyone, yes. But,
If anyone.
no, of course, we're not suggesting that. But if only, I mean, it is so rare for a British citizen to be sanctioned. It's so rare for the director of a FTSE 100 company to be sanctioned. And his citizenship, yes, they knew he was a citizen, but there's nothing in the sanctions designation form to suggest that they understood or had in mind at the time that they designated him what the consequences would be abroad as well as in this country.
I mean, that's test 4. I get that. That's the balance. And you say this is obviously something that shouldn't have been considered to be balanced in favour of taking this drastic step against this person. I get all that. But I'm asking about your suggestion that it's arbitrary because other directors of Evraz who were in a different position were not sanctioned.
Well, one of the things the guidance might have said...
Sir Michael Peat is hardly comparable to Mr. Shvidler. I think even he would accept that. So, is he Sir Michael?
Sir Michael Peat?
Yes, yes.
But they were both paid by Evraz. Which
Right, no, I get it, but he probably didn't. I don't know.
Mr. Abramovich.
I don't know if it's suggested that. Well, okay, but I don't know if it's suggested that he was had the same association with Mr. Abramovich.
The association for both of them is put on the basis of the payment,
Right.
and they put it also, in my case, on the basis of the fact that he'd worked for Sidnef, I think, before 2005. It seems rather impossibly distant. So it's a narrow basis.
Well, I think the impossibly. I mean, I think you've got to be a bit careful about saying, well, it's impossibly distant. I mean, if it were right, and I've no idea if it's right or not, that they were best friends, right-hand man, etc., that surely is relevant to the closeness of the association.
Well, of course, to the extent that one can take into account the association under the regulations,
Okay,
yes. And my argument is the extent to which that case is made out.
Okay.
I'm looking at the evidence that's relied on against me. So, I mean, it's plainly, at the very least, it's a principle of good administration, as these cases have said, that there should be guidance. And the purpose of good administration, one of the purposes of it, is to make you less vulnerable to judicial review and to legal challenge. And if you have a extraordinarily wide discretion like this one, and you don't have any guidance, then it is a factor, we say, that makes you vulnerable to suggestions of behaving arbitrarily. And if you look at it from Mr. Shvidler's point of view, I mean, he's described by a government minister as one of Putin's cronies and someone who'd benefited from Russia's aggression in Ukraine. He's initially designated on the basis of all sorts of allegations, apparently taken from the internet and suddenly and then withdrawn, that he'd been given a yacht and a Ferrari, that he was the director of a company that managed Mr. Abramovich's assets, that Mr. Abramovich was involved in seeking to destabilise Ukraine, and then large elements of those allegations were abandoned. But the case for designation mysteriously remains unaltered. And you know, when my learned friend suggested below, and this is footnote 24 to our skeleton, he said that it was extreme and absurd to suggest that the chairman of a FTSE 100 company might be designated. He was saying how, I was saying, well, under these regulations, it would be open to the, I took the point on BP, it would be open to the Secretary of State to designate the chairman of a FTSE 100 company. And he said, well, it would be extreme and absurd. But really, by saying that, my friend was demonstrating how the process is indeed arbitrary. I mean, Mr. Shvidler wasn't the chairman, but he was a non-executive director of a FTSE 100 company. And he was directed, he was designated, and so were others. So that's what we say about that, about arbitrariness and discrimination. Lords, Lady, I come on to ground 1B, which is association with Mr. Abramovich. And just for your reference, it's paragraphs 98 to 104 of the judgment, and it's our skeleton, paragraphs 41 to 46. And this ground of appeal has three parts. It relates to the issue of whether Mr. Shvidler was associated with Mr. Abramovich within the meaning of the regulations. And that, as I've sought to explain, is the crucial basis for his designation, because it's the only one that differentiates him from any other British citizen who'd previously conducted business in Russia. And that's why one has to give close scrutiny to the Secretary of State's assertions as to the nature of Mr. Shvidler's relationship with Mr. Abramovich. And I'll remind you, we probably don't need to go back to it, but in the regulations, Regulation 6.2d has the rubric that associated with includes obtaining a financial benefit from that person and being an immediate family member of that person. And the three parts of this ground are set out in my grounds of appeal, tab 2, starting at page 13, and the three are actually set out on 14. And the first issue is whether there were reasonable grounds to suspect that the appellant received significant financial benefits from Mr. Abramovich, as opposed to companies with which Mr. Abramovich was involved. And that's paragraphs 99 to 101 of his judgment. And as I mentioned just now, the Secretary of State puts his case first on the basis of remuneration from Sidneft prior to 2005. And as we point out in our skeleton, paragraph 14, that was so long ago, it can have had no possible rational connection to the matters in hand. It was 9 years before Crimea was even invaded. And the answer to that type of situation, we say, is given by Mr. Justice J in the Synesis case. It's Authorities tab 40, page 1900. At paragraph 25. This is a case under the Republic of Belarus sanctions regulations, which were incidentally rather broader in their application, in their purpose, their objective, than the Russian ones. But they also relied on the definition of an involved person. And so when he talks about the 2019 regulations, he's talking not about our regulations, but about the Republic of Belarus Sanctions EU Exit Regulations 2019. And he says at 25, the definition of involved person under both SAMLA and the 2019 regulations is broad, inasmuch as it includes an entity who has been involved in a relevant activity. In situations where that involvement has not been recent, there may well be an argument that designation of the person should not occur in any reasonable exercise of discretion, although, and in whatever terms the argument is precisely formulated, that would always be a question of fact and degree for the judgment of the decision maker. Then,
That's right, is it? You say?
yes, we rely on that, yes.
It's always a question of fact and degree for the judgment of the decision maker.
Well, it may be that one doesn't
I
need to
thought
spend...
that's not quite what you say.
Well, it's going to depend. And we, in our submission, to rely on, for a start, this is a very obvious point, the money was received from Sibneft. It wasn't received from Mr. Abramovich. He was employed by Sibneft. Then that's where the money came from. But even beyond that, as a point, it was so long ago that, given the objective of the regulation, as set out in Regulation 4, being all about stopping aggression in Ukraine, it is very difficult to see how a reasonable decision maker could have thought that having taken money from a Russian company before 2005, which Mr. Abramovich controlled, was...
But we're not deciding whether this was a decision that a reasonable decision maker could have made, are we? I mean, we have to be... This is why the test is so important.
Yes, well, I'd like you to be more intrusive than that. I'm simply saying that in this particular issue, you perhaps don't need to be, because it's very hard to see what possible...
And you know, the point, I mean, the reason I'm questioning it is that it seems to me that timing, I mean, if it were the case that this appellant was a very close friend and associate, business associate of Mr. Abramovich, and he
yes.
was what I think is said about him, then the fact that that is demonstrated by what happened years ago is, it doesn't really matter whether it's years ago or not if it's still the case.
Well,
I mean, that's my question to you. I don't really see why the timing in a situation of this kind makes all that much difference. I can see it might, if it was a long time ago and it's all disappeared now, but if it's not disappeared now and the relationship is still as strong now, which I think is what is said against you, then what does timing matter?
but you still, if nothing else, have to fall within the scope of the regulations. You have to have received a financial benefit from
Sure.
Mr. Abramovich.
Sure.
Now, there were 70,000 employees of Everaz, and the same point is made in relation to Everaz.
Yeah, but they weren't all Mr. Abramovich's right-hand man.
They weren't all friends of Mr. Abramovich, no, and you will decide, no doubt, when you give judgment in this matter, whether Regulation 6 extends so far as to include friends or business partners. And the court will decide what it thinks about that, and I'll
Yes.
give you my submissions on it.
Yes, absolutely.
But we do say that the simple answer to the Sibneft point, and indeed also to the Everaz point, is that even if those companies were owned or controlled by Mr. Abramovich, then the remuneration received by Mr. Shvidler was from those companies and not from Mr. Abramovich.
Yeah.
I mean, my friend in his skeleton, paragraph 29, seeks to place importance on the fact that Mr. Shvidler referred in a letter, I think it might have even been my instructing solicitors, referred to Sibneft as Mr. Abramovich's company. Well, with the highest respect to Sir James and his team, this is pretty desperate stuff. You know, one might refer to Virgin as Mr. Branson's company. That doesn't mean that employees of Virgin are obtaining a financial benefit from Mr. Branson. They're being paid by Virgin for their work for Virgin. And the same is true here. The second issue under this head is whether Mr. Abramovich owned directly or indirectly a majority of the shares or voting rights in Everaz. And the judge's conclusions on this are at 103 to 104. He concluded at 103 that Mr. Abramovich, so Mr. James was right in his submission, that given that Mr. Abramovich, Abramov and Frolov are treated by Everaz as acting in concert, there are reasonable grounds to suspect, those useful words, that there exists a joint arrangement between them within the meaning of paragraph 3. Accordingly, each of them is to be treated as holding the combined shares of all three, and Mr. Abramovich to be treated as owning directly or indirectly more than 50% of the shares or voting rights in Everaz. So he's saying it's reasonable to infer from the fact that they're treated as acting in concert, and I'll take you to this, that there exists a joint arrangement. And then he says at 104 that this is enough to establish that his remuneration as a director can properly be regarded as a financial benefit obtained from Mr. Abramovich. Well, nor we say that both those conclusions are wrong. And on the first one, in summary, there was a great deal of evidence on this. And I'm going to just need to give you a flavour of it, I'm afraid. And I'm going to have to take you, first of all, to the regulations. The bits that I didn't take you to before, because I said it was better to address them in the context of the submission where they came up. So if I could take you to Regulation 7, it's in the authorities bundle at 132. Regulation 7 says that a person who is not an individual is owned or controlled directly or indirectly by another person if either of the following two conditions is met or both are met. The first condition is that P holds directly or indirectly more than 50% of the shares in C, holds directly or indirectly more than 50% of the voting rights in C. Those are the relevant passages. And then looking forward to 194, you'll see that Schedule 1 contains provision applying for the purpose of interpreting paragraph 2. Page 194, we have Schedule 1. If shares or rights held by a person and shares or rights held by another person are the subject of a joint arrangement between those persons, each of them is treated as holding the combined shares or rights of both of them. A joint arrangement is an arrangement between the holders of shares or rights that they will exercise all or substantially all the rights conferred by their respective shares or rights jointly in a way that is predetermined by the arrangement. And it's also true that, as Mr. Shvidler himself volunteered in his second witness statement, Mr. Abramovich and two other directors are regarded as a concert party for the purpose of the UK Takeover Code, and therefore as controlling shareholders within the definition in the FCA's handbook. And the reference to that, I don't think I need to take you to it, the supplementary bundle, page 253 at paragraph 54. And so far, so uncontentious. But what the Secretary of State then does with the agreement of the learned judge is to infer from the position under the Takeover Code that there is, or at least there is reasonable grounds to suspect, a joint arrangement for the purposes of the regulations. And points I'd make on that are as follows. First of all, paragraph 43 of our skeleton, the Takeover Code rules were devised for the specific situation of a takeover. And as we say at 43.3 of our skeleton, parties may act in concert to thwart a takeover bid, but otherwise act independently in relationship to their shareholdings. Then the next point we made is that the parties had indeed put in place arrangements to do precisely that. And relationship deeds were put before the Secretary of State and in evidence before the High Court, whose intent was to ensure that Mr. Abramovich and his colleagues would not exercise various rights so as to enable Evraz plc to conduct its business independently of the controlling shareholders. And the reference to that is Mr. Shvidler's second witness statement at paragraph 60. It's the supplementary bundle at 256 to 259. And then the third thing we say is that...
Do you accept inadvertently that they are controlling shareholders? That they're not going to do certain things, but they are controlling shareholders?
They had entered into a relationship deed which took them outside the scope, we say, of the definition in Regulation 7 and Schedule 1. And to add to that, there were witness statements before the High Court from Sir Michael Peat and 4 of his fellow directors to the effect that this was so. That they had enabled Evraz to conduct its business independently of the controlling shareholders. And the reference to that is Mr. Shvidler's second witness statement at 61. And reasonable ground to suspect may be a very useful filter, it may be a very broad test, but we say it does not entitle you to ignore the evidence in favour of a broad inference of this kind, because the Secretary of State saw the relationship deeds, saw the evidence, but still drew the inference based on the position under the Takeover Code. And we say the court was in error at paragraph 103 by accepting it. Well, that's the long answer. The short answer is the judge's second error at 104. Even if the Secretary of State was right about there being a joint arrangement, it still wouldn't establish that Mr. Shvidler received a financial benefit from Mr. Abramovich. His remuneration as a director came from Evraz and not from Abramovich, regardless of whether Abramovich was a controlling shareholder or not. So contrary to what the learned judge found at 104, that remuneration cannot properly be regarded as a financial benefit obtained from Mr. Abramovich. Same point we have on the other company. Lord, the third issue is the pure issue of law, which the court will want to decide, I'm sure, not only to decide this case, but because of guidance it may give for other cases. But the issue is whether, even if Mr. Abramovich did not confer financial benefits on Mr. Shvidler, so if I'm right about that, whether their long-standing personal and business relationship could still be said to be an association between them within the meaning of the regulations, Regulation 6.2d and 6.6. This comes up in paragraph 98 of the judgment, where I think it's fair to say that the judge is not entirely clear on whether he was deciding the point or not. He said at 98, there is no doubt the claimant is a long-term friend and business associate of Mr. Abramovich. This is accepted by the claimant and has been known to and taken into account by the Secretary of State. In my judgment, the Secretary of State also had reasonable grounds to suspect that the claimant had received significant financial benefits. Well, we said in our grounds of appeal that if the judge was there holding that he could be associated despite not having received financial benefits, that was wrong, and my friend picked up the point and ran with it as an alternative argument, and he puts that in his skeleton argument at 33, paragraphs 33 to 36. So what we say about that, if your lordships wouldn't mind just pulling up Regulation 6, it's at page 123 of the authorities bundle. Just to remind your lordships, you see that 6.2d has the concept of associated with, and 6.6 associated with includes obtaining a financial benefit or other material benefit and being an immediate family member of that person. And I make two preliminary points on that. If the definition was intended to include any kind of business relationship, then why does 6a refer only to the obtaining of financial benefit or other material benefit?
It says includes.
It does say includes, indeed, indeed. That doesn't mean it includes everything. And if it was intended to apply to friends, then why does 6b apply only to family, and specifically to immediate family members, which are painstakingly specified on the following page, 126. Well, the next point we make on these regulations is that they need to be construed conservatively because of their great power to impinge on fundamental rights by catching peripherally associated persons within their ambit. And I'd like to show you a report that was laid before Parliament at the time these regulations were made. It's in the authorities bundle 2448, tab 51.
No objection to looking at this.
I don't think my friend objects, and it's referred to 2248. I'm sorry.
I thought so. There weren't enough pages.
This is a report under Section 2.4 of the Sanctions and Anti-Money Laundering Act 2018 in relation to the Russia Sanctions EU Exit Regulations 2019. So this is a document that was laid before Parliament at the time these regulations were made. And the relevant passage is on 2250, halfway down, under the heading A, Financial and Immigration Sanctions on Designated Persons. It says these restrictions consist of an asset freeze, including a restriction on providing funds and economic resources, and a travel ban. These restrictions can only be imposed upon specified individuals and entities who meet the criteria set out in the regulations, and at paragraph 5 above, paragraph 5 reciting what you've already seen in the regulations. This is in order to ensure that the sanctions are clearly targeted at those who are or have been involved in the destabilisation of Ukraine, etc., and therefore fulfil the stated purpose of the sanctions. The reference to destabilisation of Ukraine, etc., if you look back to the previous page, 2249, under little a, you've got the definition of involved person who has been involved in destabilising Ukraine or undermining or threatening the territorial integrity, sovereignty or independence of Ukraine. And that, of course, is also the stated purpose of the sanctions, directed to ceasing Russian activity in Ukraine. So you see there the expectation that they would be conservatively construed. And there's a second reason of legislative history for suggesting that a cautious interpretation is in order, and that is the fact that it was felt necessary in 2022 to extend the scope of the regulation to refer to immediate family members. And I can take you to the explanatory memorandum to the amending instrument. That is in Authorities Bundle, tab 52, page 2253. This is the explanatory memorandum. I'm so sorry, tab 52.
Thank you very much.
This is the explanatory memorandum to the 2022 regulations, the ones that actually made quite a few of the changes that we've been looking at today. And the instrument is made under SAMLA in order to make amendments to the 2019 regulations. These amendments will amend the designation criteria to specify additional activities for which a person may be designated, expand the scope of those involved in obtaining a benefit from or supporting the government of Russia, and broaden the definition of associated with to include specified family members. If you look at 6.6, before these 22 regulations were passed, it simply said in paragraph 2d, being associated with a person includes obtaining a financial benefit or other material benefit from that person. And it was broadened to include immediate family members, but only those specified family members. You'd think if the mind of the Secretary of State was on broadening those regulations, and the only illustration given of associated with was obtaining a financial benefit or other material benefit, that had they wished to include friends or business partners more generally, they would have said so, but they didn't.
Would you accept that as a matter of ordinary meaning, the word associate would include a long-standing friend or business associate?
Well, people might use it that way, but in the context of this case and of this very broad set of regulations imposing great hardship potentially on people, I think it's important in my submission to stick to the words of the regulations. And I've given you my reasons for why they should be conservatively construed. And of course, it was broadened only to immediate family members, not to more remote family members, not to friends.
I see that, but I see that the list includes, for example, grandchildren. One often sees these kinds of inclusive definitions, so that something is put beyond doubt, because otherwise you'd have to have an argument about it, you might have to consider evidence, questions of fact and degree. So certain things are put beyond doubt simply through the definition clause. It is a non-exhaustive clause. Would you accept that?
Accept the word includes is suggestive that it's non-exhaustive, but that the clause takes its colour from the illustrations that are given.
Yes, I see.
And I think if one wanted to argue that a great-grandchild, say, was an associated person, you might find that was a very tough argument to make, because the legislator has addressed themselves to the categories that should be included and hasn't come up with that solution. And I'd apply the same logic here. You have the points.
I do.
Those are the points I make on association. And I come now to the ground 1C, which is rational connection. Or, in the words of Lord Sumption in the Lord Carlisle case, is the measure capable of contributing systematically to the desired objective? And we say the requirement of a rational connection is a very important limb of the proportionality test, because in the absence of any statutory limitation, it is a primary safeguard, perhaps the primary safeguard, against the potential designation of all those thousands of people, no doubt many thousands of people, who satisfy the low threshold for designation in Regulation 6. And I showed you Lord Carlisle, paragraph 34. It must review the rationality of a supposed connection between the objective and the means employed. Is it capable of contributing systematically to the desired objective? And the learned judge cited that at paragraph 88 of his judgment, and again at paragraph 128. I've shown you abortion services, paragraph 31, and the need for you to carry out your own assessment, not to accord any deference to the assessment of the court below. So where then did the court go wrong? And I take the errors from the grounds. Some, as is evident from the grounds, apply not just to rational connection, but to other aspects of the proportionality assessment as well. So looking at my grounds, page 15, I'll start with a ground that applies both to fair balance and to rational connection. It's the one at the bottom of page 3. And here we have a crossover between the two appeals before your lordship, your ladyship. In applying obiter remarks of Sir Ross Cranston in Dalston Projects to the assessment of fair balance, we say that the judge erred. Both rational connection and fair balance properly fall to be demonstrated by reference to individual designation decisions and not by reference to the cumulative effect of all the measures imposed under that regime, together with other types of diplomatic pressure. So that submission is made in relation to both fair balance and rational connection. If I could take you to the Dalston Projects judgment on that, it's tab 41. It's around in the 1900s. It's 1933.
Which paragraph?
Paragraphs 85 to 86. And at the bottom of 84, Mr. Justice Johnson says that given the likely direct and indirect links between Mr. Naumenko's wealth, economic activities and the Russian state, it is rational to consider that Mr. Naumenko is a sort of individual economic actor on whom sanctions could affect the broad and deep impact which Parliament intended, either connected with Russia powers and at least weakening their tacit support for the regime. Absent from the rational connection analysis is evidence regarding the efficacy of a detention decision on the legitimate aim of deterring Russia from its actions in Ukraine. Here Mr. Naumenko's property has been detained, but it is unclear what contribution this will make in influencing a situation for which he is not directly responsible and over which he has no control. Officials fairly conceded this, for example, in the ministerial briefing for the January 2023 decision. In the Bank Mellat case, the order restricting the access of an Iranian bank to UK financial markets so as to inhibit nuclear weapons in Iran was held to be disproportionate, inter alia because it was disproportionate to any contribution which it, and I emphasise that word, could rationally be expected to make to its objective, per Lord Sumption. The difference with the Bank Mellat case is that their disproportionality followed because Iranian banks other than Bank Mellat are not affected by the measure. In this regard, I accept Mr. Pobjoy's submission that the Secretary of State need not demonstrate the efficacy of each individual detention or designation decision in order to maintain a sanctions measure. Certainly, it would be difficult to demonstrate that any one decision would have the desired foreign policy outcome. It is not an issue for the court. In the end, all that is needed is a rational connection between the sanctions measure and the aim. Additionally, the Secretary of State is granted a broad measure of discretion in a case such as this to decide that the exercise of the sanctions power is needed when coupled with other measures as part of pursuing the UK's foreign policy objectives.
Is that last sentence correct in relation to this part of the test?
No, certainly not in the context of our case. When you look at the evidence that was before the Secretary of State, and when you look at the nature of the decision that needed to be made in relation to rational connection, and indeed the fact that the reasoning on rational connection is ex post facto, and I'll come to that in a moment. But the difficulty that Justice Johnson faced was the fair concession, as he put it in 85, that it was unclear whether this measure in relation to Mr. Naumenko's property would would make any contribution. And so he resorts to this doctrine, which one might describe as collective rational connection, that in that case it doesn't matter. One can have regard to, you don't have to look at the aspects of each individual measure, it's enough to look at them collectively. And that was cited by Mr. Justice Garnham in my case, Mr. Shvidler's case, at paragraph 136 to 137, and he found it relevant both to the rational connection analysis and to the fair balance analysis. He said the effectiveness of any sanctions regime depends not on the effect of a particular measure directed at a single individual, but on the cumulative effect of all the measures imposed under that regime. He refers to the Dalston Projects judgment on that. So we have these notions of collective rational connection and collective fair balance, if I may call them that. And we submit that neither of those can be correct as a matter of principle. The proportionality test is, in a human rights context, formed by reference to the impact of a measure on an individual and the contribution of that measure to the legitimate aim that is asserted. So if you look at Lord Reed in Bank Mellat, paragraph 74, we might just bring that up. It's at tab 27, page 1430.
I mean, just before you go there, might it be right that it is correct so far as the rational connection is concerned, but not necessarily as far as the fair balance is concerned?
Well,
I mean, I completely understand your submission.
Yeah.
That when you're drawing a fair balance, you obviously need to look at the measure itself compared to the problems it causes the designated individual.
yes.
But so far as rational connection is concerned, it seems to me impossible to necessarily say that any single person would have a desired effect on somebody like Mr. Putin's war decisions, but the collective might. I mean,
Well, you have to see a plausible way in which it. You have to see. I think it was put it by Lord Sumption in terms of a rational expectation that it would have an effect. That's what you need.
Yeah.
If there is some rational expectation, even a slender one, then one needs to move on to the third and fourth aspects.
Well, that's the point. I mean, you know, there was accepted in that case that certainly it was accepted in Belmarsh that locking one prisoner up would have some effect on reducing terrorism, but maybe not a very big one. But then they moved on.
Yes.
And what I'm asking you is could it be that it's correct as regards test 3, but not as correct as regards test 4?
So correct on
You
rational.
don't have to agree, Lord Anderson. I'm only suggesting it as a possibility.
Well, I'm very happy if it's correct on test 2, then and the doctrine is applied on test 2, then one rational connection, then one wouldn't need to get to tests 3 and 4, the less restrictive alternative.
Well, no, I'm putting it really the other way around, aren't I?
Yes, I see.
So that you would get to test 4,
Yeah.
but you would get to test 4 with the ability to look at the individual measure intact.
No, we say that in the fundamental rights context, we'll come on to test 4. I'll show you the law on that. But we say there again, it is an individual
So that's the point I'm putting to you.
Just as, of course, when you look at it from the other point of view, when one's looking at the hardship, I would love to, I can't rely on the collective hardship of all people affected by sanctions. No doubt that would give me a very mighty argument.
No, of course not. Okay, you
But it's an individual analysis on both sides, and we say for both parts of the test. We'll just sort of decide whether that's right.
Would it follow that if 100 people are designated, all 100 could come to the court and say, well, individually, each of our cases is going to make no realistic contribution at all, and so you have to discharge the order in respect of all 100?
Well, if you look at the way that explanatory memorandum was phrased, and the need to focus these designations on people in respect of whom there was, I forget the words they used, a real prospect or a rational expectation, then that would be the test. But I think one has to look at this submission in the context of what is said about rational expectation and just how theoretical and indirect the routes that have been devised, largely after the event, are in order to see the force of the submission. But if I may take it just as a matter of law at the moment, on the Shvidler test, I was taking you to Bank Mellat at 1430. It involves asking whether, this is 4, balancing the severity of the measure's effects on the rights of the person to whom it applies against the importance of the objective, to the extent that the measure will contribute to its achievement, the former outweighs the latter. And then going on to 116, still in the speech of Lord Reed, judgment of Lord Reed, you can see that it could, however, reasonably be expected to realise the objective of hindering the development of nuclear weapons, at least to some extent. That is sufficient to establish a rational connection between the direction and its objective. So the test is, could it be reasonably expected to realise the objective at least to some extent? And that was a test which Lord Reed had no difficulty in applying to the designation or to the direction in relation to Bank Mellat. And we say that's a realistic test, and it's a test that is sanctioned at the highest level. And indeed, Lord Sumption, in the same case, really agreed. And if we go back to 1413, paragraph 27, again, he's talking about the direction on Bank Mellat. He says in the last sentence of that paragraph, the direction was irrational in its incidence and disproportionate to any contribution which it could rationally be expected to make to its objective. Of course, no one's suggesting that a single designation has to achieve the objective. It has to be able to make a contribution to the objective. That's the test. It's quite a modest test. But it does require there to be some point to these very onerous measures. So that comment was in the context of fair balance, but the unfairness, we say, is equally obvious in the context of rational connection. If someone has been sanctioned without any expectation, any rational expectation, that the sanction will contribute to its objective, then the deficiency cannot be rescued by the fact that sanctions were also imposed on other people where some rational connection did exist. And the doctrine was a way for Mr. Justice Johnson of solving the problem that was before him, but it is not, we say, correct in law. So that's the first error under rational connection. And Lord, the second error, we say, is that the learned judge took too deferential an approach. And that is also raised in our grounds of appeal. We accept that the existence of a legitimate objective is a matter of foreign policy, on which it's most unlikely that a court would seek to second-guess the Secretary of State. We did not invite the court below to do so. But the position is otherwise in relation to the other elements of the test, on which no special deference is due to the Secretary of State for these reasons. First, and this is ground 3A, and the reasons are really 3A, 3B, 3C in our ground 1C on page 14 of the core bundle. There is nothing material to the Secretary of State's decision-making process that has not been disclosed already to this court in the form of newspaper articles, websites, and evidence. And we deal with this at paragraph 54 of our skeleton. I go back, if I may, to 52. This is the section on rational connection. In fact, even to 50. 50 explains how the connection was expressed in the decision under review back in November 22. And it said to the designation of Shvidler is likely to contribute. So the Secretary of State itself was assuming the burden that we seek to place in him, that the designation of the individual is expected, or could be expected to contribute in certain ways. They weren't saying that it was likely, in conjunction with 1,600 other designations. They were saying his designation was likely to achieve in at least the following ways: a strong political message, incentivise the government of Russia, signal UK's full support for implementation of obligations. Then we comment on that at 51, and why we said they were inadequate. Then at 52, in response to this claim, so this is once we're before the court, the FCDO took a different tack and stated that the designation would contribute to the objective in 8 specified ways, which are considerably more elaborate than those which the respondent himself approved and set out in the amended SDF. And the evidence in support of those conclusions, we say, is scant. It takes the form of the vague and general conclusory statements set out in the first statement of Mr. Reid, which even he, as director of the FCDO Sanctions Directorate, refers to in his second statement as assertions. I don't take you to that now. But what happened next when we got that response? That was the equivalent of the detailed grounds of resistance in judicial review. When we got the response, we sought an order under CPR 79 requiring the respondent to file and serve further information about the response, essentially seeking disclosure of the material on which these new reasons were based, and the material which the Secretary of State had before him at the time of the decision under challenge. And if I take you to the supplementary bundle at page 231, I can show you the Secretary of State's response. You see our requests were set out on page 232 of the supplementary bundle. The response is given at 233 to 234, and says the Secretary of State's conclusion that the designation of the claimant would have the consequences described in those, I think that should be 1 to 7, but anyway, no, it is 8, sorry, in those 8 paragraphs, was based on the Secretary of State's consideration of the available evidence at each stage up to the present court review, including extensive documentary evidence and detailed representation from claimant himself. The Secretary of State's conclusion that the consequences described would contribute to the objective of encouraging the government of Russia to cease all its actions in Ukraine was based on the totality of the material particularised below: overall judgment, institutional expertise, understanding of the operations of the Russian government, analysis of the Russian political economy, including the analysis of Russian political economy set out in the updated SDF in relation to Roman Abramovich and the accompanying SDFE. So that's Mr. Abramovich's SDF and his exhibits. Then the decision-making process in relation to the claimant's designation is described by Mr. Reid. At each stage, he considered the following material: in making the original designation, ministerial submission, the SDF, the SDFE. In varying the designation, the updated ministerial submission, the variation SDF, the variation SDFE, with its 10 exhibits, as you see. In varying the claimant's designation following a ministerial review on 11th November 2022, the Secretary of State considered the claimant's request for revocation, the accompanying letter from Peters and Peters, the ministerial submission, the ministerial review form, the SDF, and the SDFE. And preparing the witness statement of Mr. Reid, officials considered the 31 exhibits annexed to that statement, as well as various other court documents and witness statements, including the witness statements I referred to on control of Sir Michael Peat and the other directors. So the first thing we say about that is that the respondent did not rely on any evidence that was not disclosed and placed before the court. There was no application for a closed material procedure as provided for in SAMLA, with disclosure only to a special advocate. The court below had before it all the material that was relied on, as does this court. There was nothing in the evidence before it to support a conclusion that so far as the evidence taken into account was concerned, the Secretary of State was better placed to make an assessment than the court. And the judge went too far when he concluded to the contrary at 116. Well, the second and related point...
Lord Anderson, I'm sorry to tell you I have to rise promptly
Yes.
at 4:15.
Yes.
So we'll have to continue. Tomorrow? How much have you got left?
I've got about a quarter of my submissions left.
Have you?
So I would
And how long is the Dalston case going to take?
Well, Lord, we have the same time estimate of a day and a half for the hearing. Obviously, there's a degree of overlap, no doubt, in the submissions that Sir James will make in response. I think I'll be somewhat less than a day, but I know that I'm not the first person to express that hope.
Well, I think that's not really feasible. If you were a day and Lord Anderson doesn't finish until 12 o'clock, which is what he's indicating effectively, that leaves no time at all for Sir James, which is totally unsatisfactory. I think you'd better consult amongst yourselves, all counsel, and decide on a timetable for the rest of the hearing. I'm obviously, my fond hope that we finish in less than 3 days is not being realised, but we won't be able to go over the 3 days. So I suggest that it's been a bit of a hot afternoon in this court. So tomorrow we're going to convene in the cool lower regions of Court 71, and perhaps we'll start by deciding how long it's all going to take. But you will have to spread the time evenly amongst you.
yes, understood.
All right, very good. We'll see you all at 10:30. Thank you.
All right.
We can commit to this.
Yeah. Well, I think of a Friday.